Ramona Hage-Morrison. How many have heard of the Hage Family Ranch out of Nevada? After 22 years of battling against the federal government, with Danny's help, the Hage family won a 22-year case against the Department of BLM, and Ramona will give you a brief background on that, but here's Ramona Hage.
Thanks, Debbie. Good to be here with all of you, and we're all in this battle together. I think my mom and dad thought they were the first ones in it about 1978 when they bought the ranch and the relationship with the Forest Service and the BLM. So that was the epicenter initially, but this thing is all over now. The battle for property rights, water rights is across the West. It doesn't really matter which community you go into. This community here has been at it for many, many years. Well, about since the 70s, haven't you? And so these are the battles that we're all engaged in, and what we hope to bring to you guys and to folks across the West at Liberty and Property Rights Coalition is some battle strategy, for lack of a better word. Because we are here with limited resources and limited time. Because believe it or not, we're all still producing. And so we don't have time to hang out in Washington, D.C., following all of our politicians around and lobbying them. Now the Park Service and the Department of Interior and the Forest Service have full-time lobbyists back there. And I was back there one time on the Endangered Species Act following a Park Service bureaucrat around as a lobbyist. And I thought, how do we compete with that in the private sector? But we do compete with it by being effective, by being very effective in how we handle in how we plead our cases if we have any kind of litigation, in taking the hard lessons we've learned through years and years of litigation to fight smart and effectively in the courts, as well as politically and in the public relations arena. I'm going to offer a couple comments on that score. And Danny's going to elaborate in more detail. But I worked in Congress. And there's 535 of those folks back there. And if you want to influence them, you have to basically influence the entire country. It's physically almost impossible, especially for those of us in agriculture who are such a small block of the voting block. However, if you listen to everything that has been said so far, so much of it is being implemented on the local level. And that's really one of the most powerful, well, I'll tell you, a couple of the most powerful offices in the country are the county commissioner or supervisor and the county sheriff. And it's a job no one wants. It's not really a fun job, especially a supervisor. But it is one of the most powerful ones. And why do you think the NGOs, environmentalists, and state and politicians always go get those supervisors or county commissioners' support before they implement stuff? If they can get the county commissioners on board, they've got the job done. Well, we need to do the same thing. The same is true for the sheriff. The sheriff is so critical in some of the things that we're dealing with, and we need to have a close working relationship with our sheriff. We were involved in some very significant battles in Nevada over, anybody know who Bob Abbey is? Former head of the BLM? Nationally, we trained him in Nevada. And he got pretty good at stealing cattle in Nevada. And in fact, he had a contract issued to confiscate over about 5,000 head of cattle from various ranchers in Nevada. And we set up a little organization. Don Alt here was a part of that. We had a cohesive board without a reverse gear. And we determined there were going to be no more cows stolen in Nevada. But what we learned from that was that the battle is local. The battle is in the state. The battle is with the sheriff. The battle, or hopefully not the battle with the sheriff. And the battle is with the local officials. And we got to the point after a few people had their entire livelihoods taken off the ranch in a cattle truck, sent down the road to some slaughterhouse, sold, and the proceeds kept. We determined, we got a little fight in us, that we weren't going to take it laying down anymore. And I'll be quite honest, and I don't mean to step on anybody's toes, but my attitude when politicians sign agreements that destroy your property rights, or local board directors sign agreements that destroy your property rights because it's uncomfortable to go against whatever the pressure is that they're under, and your livelihood is destroyed as a result result. I'm kind of the opinion we need to reinstate tarring and feathering, or maybe recalls, or some other thing. We need to hold our county and local officials, irrigation district officials, all these people with board positions. I'm on the Board of Agriculture in Nevada, and so I'm in the same boat. But we do need to hold our local officials accountable. I had some bedtime reading last night, and it was wonderful. Your Klamath Basin Agreement. And it worked perfect. I slept perfect. And I was trying to read it, but it was very interesting to look at the signatories on that agreement. And to be honest with you, I was a little horrified to look at the signatories on that agreement, because it was local officials and local irrigation districts. And I don't know what to tell you. But if you don't get control of your own politics here, as Michael had mentioned earlier, and hold people accountable, you're going to continue to have the same problem. We've got to get a grip on these issues. Yeah, well, my dad almost went to jail too. I know exactly what you're talking about. No, we're in a very serious battle, you guys, and I don't mean we're beyond the point of playing patty cakes, and I think that's what I'm getting to. For a long time, we could coast and we could let things slide. We're really not there anymore. So, I would like to talk a little bit. First of all, we have a sign-up sheet for Liberty and Property Rights Coalition. It's to receive the newsletter. Some of you guys are already receiving it. It's a weekly newsletter, and then shortly, well, we've had our website hung up in Uruguay. We hope to get it out of Uruguay and get it here stateside. But we will have a website, and in that website, we want to have resources for property owners that you can go to on that website and educate yourself or answer some of your questions and so forth. So it's going to be a property owner's resource tool in addition to a live news tool. Anything having to do with property rights across the United States. So if you get our newsletter, you'll know when that website is up finally, and we'll keep you in the loop that way. I have here it's a program that I've put on across the West on title research. In our case, in 2007, the government filed a trespass charge against my brother and the estate. What had happened? What's that? Oh, yeah. What had happened was we had, of course, I think all of you are aware, the long-standing case in the U.S. Court of Federal Claims. The government had denied us our grazing permits. They revoked them. But we basically still owned all of the underlying rights on which those grazing permits were based. The vested water rights, the rights-of-ways, the ditch rights, the roads, the fences, all these various property interests all arising on federal land. And so we had those rights. We couldn't use them, allegedly, because we didn't have a grazing permit. And they refused to give us our refused to reinstate it, I should say. So finally, my dad and my brother determined that they were going to have to force the issue, because we had some language in the court decisions out of the claims court, out of those 8 published decisions, that basically said we had some right to a forage right. And we figured we're going to have to force that issue, so they turned out cattle in about 2002 without a grazing permit. It was all, not something I necessarily recommend if you don't have the court cases and some of the stuff behind you that we had. But nonetheless, that was the position we were in, and we decided we better force the issue. So in 2007, the government finally responded about a year after my father died with a trespass charge against my brother and the estate. And out of that case, how many of you have heard of this ruling yet? Okay, so I lost my... Am I there? No. Hello? I'm out of juice. I've been told I need to kiss this mic. Can you hear me? Yes. Okay. So anyway, Yeah, I guess so. There we go. So anyway, out of that, of course, we had some interesting findings. In addition to a recognition of our forage right, and in addition to it putting us under permanent injunctive relief in this court, and ordering the government to reinstate our grazing permits, and my brother to apply for them, and so forth. Then we had some interesting findings in that as well with regard to the government, in a cross complaint that we had filed alleging that the government had been interfering with our contractual relationships and our property rights for the since the 1970s. The judge ruled that the government had entered into a conspiracy to deprive us of our property rights. It was a pretty profound ruling, and as Western cases go, it was remarkable. That is now on appeal up to the Ninth Circuit. Of course, we expected the government would appeal it. The reason I mention this is my family has been in 3 separate major court cases. The first of which was the water adjudication. That water adjudication was initiated because the Forest Service had filed Federal Reserve water rights over virtually every bit of our water in Nevada. And that's on Pine Creek Ranch. We have 2 mountain ranges, and there are a number of springs up there, about 80 springs, I believe, and then they run into 4 year-round streams. And so they filed on every bit of it. So my father went up, took their Federal Reserve water rights filings, took the map from those Federal Reserve water rights filings, and slapped a proof of vested water right over the top of it and filed that on those water rights. When the adjudication was done, we ended up with all those waters. The reason we ended up with all those waters is because that we could document that those water rights were vested. The government loves this Federal Reserve water right. And I'm going to tell you, we heard about Federal Reserve water rights for about 2 weeks in our trial in the claims court, the next case. And they trotted up every expert they could find on Federal Reserve water rights. And as it turned out, the judge again ruled, we showed our evidence of title, that we owned those vested water rights. Once again, we wound up in this case here in Reno, the trespass case where it ultimately became a forage right case. And, my brother's got a collection going. He was ordered to pay $176 for trespass. If anybody wants to contribute, no, just kidding. Anyway, this was after hundreds of trespass allegations. So anyway, it was kind of comical. Everybody's got a tin cup out for my brother. But as a result, once again, in that case, the evidence that we brought forward, and I happened to be the witness on that issue, was this issue of our title. That we were able to show that we had pre-existing rights going back prior to any of the land laws passed by Congress. And that some of those property rights had actually come through Indian allotments and Indian rights of the indigenous Indians that had been there since well before the 1860s. So this issue of evidence of title is critical, and it's so oftentimes misunderstood. And I'm sorry to say it is oftentimes misunderstood as much by the attorneys. And so I just urge property owners in general that we cannot be deer in the headlamps about the laws that affect us and about the property rights that affect us. Let me grab one thing. One of the things I'm going to talk about is vested water rights. And I want to go into that in a little bit of detail, of course, because it affects all of you up here. This is a photograph of Pine Creek Ranch. The Cabby, of course, is there. And the mountains behind is the Monitor Range. One of the things that helps us with property rights is understanding the nature of property. And so I'm going to read this quote to you, not to torture you too much with it, but it is important to understand how our property gets taken from us. Neither property nor the value of property is a physical thing. Property is a set of defined options. It is that set of options which has economic value. It is the options, not the physical thing, which are the property, economically as well as legally. Because the public tends to think of property as a tangible physical thing, this opens the way politically for government confiscation of property by forcibly taking away the options while leaving the physical property untouched. Thomas Sowell. Why do we need an exhaustive chain of title? That was the evidence that we provided in all three of these court cases. A chain of title is necessary to establish the time and place property rights were appropriated. In other words, we are taking our property rights back to the earliest appropriator, the first settler that was out there putting the water or whatever it was to beneficial use. And that includes the Native Americans who were putting that water in beneficial use as well. The pre-existing rights documented in the chain of title are specifically preserved in every land law passed by Congress. This is one of the things that people don't recognize. If you read FLTMA, the Endangered Species Act, the Taylor Grazing Act, the Forest Reserve Act, they all have a reservation of valid pre-existing rights in one form or another. Our rights were protected. In order for those laws to be passed, they had to protect those pre-existing rights or they would have run into a constitutional issue with those laws. The chain of title, therefore, is the primary evidence needed to protect property rights from being destroyed by employees of the executive branch abusing their discretion to circumvent the acts of Congress and the clear intent of those acts of Congress. And part of our problem as property owners, we don't bother to read those acts. Those acts, quite often, that we all gripe about are be included. If you read them carefully with this in mind, are not nearly as bad as they seem to be, and certainly not nearly as bad as they're being implemented by these federal agencies. I'm going to skip through some of this stuff because it's not all relevant. A patent to government land vests in the I'm going to read some definitions because it's very important to understand what we're talking about here. Vests in the patentee perfect legal title, which relates back to the entry of land. A patent is in many cases is a lodial title, which includes everything from the center of the earth to the sky. A deed is a conveyance of realty, a writing signed by the grantor where title of realty is transferred from one to another. These are all out of words and phrases, the commonly used definitions for some of these property-related descriptions. An appurtenance. Now this is really important because this describes your water, this describes your range allotment, and anything else attached to your property. And this is what we document in this chain of title, is our appurtenances. That which belongs to something else, a thing deemed to be incidental or appurtenant to land when it is by right used with the land for its benefit. That's Black's Law Dictionary. The word appurtenant, as ordinarily defined, is that which belongs to or is connected with someone else, to which it is subordinate or less worthy, and which it passes as an incident, such as an easement, a servitude to land, and so forth. It also includes right there the right of common pastures, you see. The appurtenance, if you read a deed or a patent, that word appurtenance is in every one of them. And when you're talking about property interests, many of our historical property interests were not, and still aren't, in Oregon, required to be recorded. Stock waters in Oregon, unless I misread the law, are not required to be recorded. So, but nonetheless, everything that is used with your patent and every conveyance of that patent forward includes all of these unrecorded appurtenances, and they are legally conveyed, either by deed or by will. So it's very important to understand that as you're going backwards in your chain of title. Okay, oh, by the way, I passed out to you that little paper on the chain of title. I'm going to go through this pretty quick because we don't all need to take a nap. But if anybody needs to do their chain of title, this gives you a lot of detail on how to go through it. So while we're going to go cruise fast here, you can go back to the reference material. An abstract of title is a condensed, it's like a index of every record that applies to your chain of title, every conveyance, every historical record, map, and so forth, in date order, one right after the other. And it's basically a summary or an index of those documents. A chain of title is successive conveyances or other forms of alienation affecting a particular parcel of land arranged consecutively from the government or the original source. The original source is often the first record you can find of settlement. It might be a survey, it might be an assessment roll record, showing that somebody was paying on a parcel of land many times, many years before it was patented. And from the government or original source down to the present holder. Now, I want to say something here. A deed is not full title. An exhaustive chain of title, what a deed is basically a document stating that there's title back there somewhere, but it is not evidence of full title. Evidence of full title on any property, including appurtenances and range, is that exhaustive chain of title bringing the entire record forward from the very first person to you. Okay, so you want full title. Full title is something that survives treaties. Full title is something that even survives national bankruptcies and changes of government. So it's a chain of title, an exhaustive chain of title can be a very important document. If you do one on your property, put it in a vault when you're done. Make sure your descendants know, your heirs know what it is, and don't throw it out. I'm going to skip through a couple of these. Okay. Vested rights. We always hear about vested rights. Let me read Oregon's law, water law. Very first, 537-120, the right of appropriation, vested rights protected. Subject to existing rights and as otherwise provided in ORS 538, all waters within the state may be appropriated for beneficial use, as provided in the Water Rights Act and not otherwise, but not contained in the Water Rights Act shall so be construed as to take away or impair any vested right of any person, of any water, or to use of any of the water. So much of the West was settled in Oregon. You guys were settled very early, and these settlements occurred well before the statutory water law. I believe this was in 1909. Is when Oregon passed statutory water law. Any proof of use of the water prior to, for irrigation, for stock, whatever it was, prior to 1908 is considered a vested water right. So let's listen to the definition of a vested water right. It is only a vested right which cannot be taken away except by due process of law. The word property, as used in the Due Process Clause, refers to vested rights. And there is not a reference to mere concessions or privileges, which may be bestowed or withheld at will. So this conditioning of our water rights that we're seeing here today, theoretically, should not be able to happen to a vested water right. In Oregon, if I understand the law correctly, I did a quick perusal, the well law kicked in around 1958, is that correct? Any well, if I understand the law correctly, prior to 1958 would be, I think, considered a vested well water right. Okay, something for you to think about. I'm going to give you guys things to think about and then go double check it with some of the people that you know. But we need to analyze these things very carefully because we need to understand where our rights are strong. A vested right is absolute, complete, and unconditional, to the exercise of which no obstacle exists and which is immediate and perfect in itself and not dependent upon any contingency. A vested right is a property interest so substantial in character that its destruction or deprivation cannot be justified by the objectives in view or any other subsequent scheme that comes along by government. The substantial value of property lies in its use. That's particularly true of water, isn't it? If you can't use it, it doesn't do you much good. If the right of use is denied, the value of the property is annihilated and ownership is rendered a barren right. That's language that Judge Smith used in our case. The constitutional right to acquire, possess, and protect property is not limited to any amount of property. So when you're talking about vested water rights, it's a matter of documenting the use historically and the amount, historically, like the amount of irrigated acreage or the number of livestock. By the way, in Oregon, just because they did not require you to record stock water rights, I don't think it's necessarily a bad idea to record an affidavit once you get your chain of title in of stock water rights. It puts everybody on notice that you have a stock water interest out on those lands, even though they were never required to be recorded. I would record that with the county recorder and with the state water engineer's office. This is another important law to the west. This is, as I said, Congress has recognized these rights historically all along and protected them in every land law passed by Congress. The 1866 Mining Act recognized what was happening out here in the West. We were settling these lands. We were coming out here in harsh conditions. Our predecessors and interests were. We were dying out here. We were living out here under very adverse circumstances. And in the process of doing that, we were laying claims to lands and water and putting that water to beneficial use and putting that water to beneficial use in many cases either by irrigation or by allowing our livestock to graze on the forage surrounding those waters. And so here's what Congress said about some of those activities. Of course, Section 8 is what we know as our Ditch Right-of-Way Act. RS 2477, road right-of-ways. It said the right-of-way for the construction of highways over public lands not reserved for public uses is hereby granted. Virtually every road in the West, if you really search the history on it, with the exception of maybe new logging roads and so forth, can be documented as a vested right-of-way. FLTMA, the Federal Land Policy and Management Act of '76, did not repeal this, but we do have to document it, and we should not be, as local governments, seeking the Forest Service or BLM's permission to manage those rights-of-ways. Those are historical rights-of-ways, and quite often they belong to the ranches and farms. Section 9 goes further and says that whenever, by priority of possession, rights to the use of water for mining, agriculture, which includes livestock grazing, manufacturing, and other purposes, have vested, oh, there's that word again, vested and accrued, and the same are recognized and acknowledged. Now listen to this language. By the local customs, laws, and decisions of the courts. The possessors and owners of such vested rights shall be maintained and protected in the same. And the right-of-way for construction of ditches and canals for the purposes aforesaid is hereby acknowledged and confirmed in perpetuity. And FLTMA didn't repeal that either, at least as it related to pre-1976 rights. That local customs laws and court decisions at the time language is often referring to pre-statutory settlement. And in Nevada and Southern Oregon and over in Hawaii County and so forth, ranches were bought and sold, ranges were bought and sold, farms were bought and sold, irrigation systems built, old ditches constructed, and there was no statute really defining any of that. But the courts upheld them once those lands were sold or conveyed by will. That was property, and it was protected as such by the courts. And so this business of needing a statutory scheme to create property is not the case. And any property that we have evidence of going back in history is actually a stronger property right. Custom and usage, Black's Law Dictionary. A usage or practice of the people which, by common adoption and acquiescence and by long and unvarying habit, has become compulsory and has acquired the force of law. Okay? So when we're going back in our chain of title, we don't ignore this custom and usage thing. For instance, ranges were sold. A lot of times they would sell the range, the cattle, the brand, and they would say where the cattle were running or sheep were running, and it would be sold in a bill of sale. That is a legal conveyance of property. Okay? Not a patent anywhere in it. Okay, now Danny's going to go into this also because it's so important, and it's where I think some of our cases are misled. The doctrine of retroactivity and prospectivity. There is no retroactive provision to the Taylor Grazing Act or the Organic Act of 1897, the Forest Reserve Act. Ranchers' and farmers' rights were created under customs, local laws, and court decisions of the times as recognized by the Act of 1866 that I just mentioned to you. But under this doctrine of retroactivity and prospectivity, the first rule of construction of statutes, and this is across the board, is that legislation is addressed to the future and not to the past. This rule is one of obvious justice, unless its terms unequivocally import that it is was the manifest intent of the legislature enacting it to a retrospective operation will not be given to a statute. Laws do not go backwards typically, which interferes with the antecedent rights or by which human action is regulation. That's Union Pacific Railroad Company versus Laramie Stock Charts, 1913. That's still true today. Okay, so let's have a look at Oregon water law, just out of curiosity. In-stream rights. The law was passed in 1987. So do you think that some of your rights predate 1987?
Yeah.
Now, I'm throwing out questions here because I know you guys have been involved in litigation, and that litigation affects you. So I'm not making legal conclusions here. I just want to throw out some stuff for you to think about. And by the way, that in-stream water rights provision happens to be subject to that language about vested rights in section 120, 537-120. Wonder how that happened. Let's look one other place that I thought was kind of fascinating. By the way, I read through some of the adjudication records. I found it very interesting that the Bureau of Indian Affairs was filing on waters under a Federal Reserve water right doctrine. Not for any Indians, looks like to me, but for themselves. Looks like a federal water grab to me. I might be reading it wrong, so straighten me out if I am. Anyway, let's look at the water rights of federal, because what we see, I think, here, what is so common on the part of these federal agencies in particular, but they've co-opted the state agencies, they've poured a ton of money into the irrigation districts, and oh, guess what? They get the results they want. And so we need to read their proposals in the light of they're in all likelihood exceeding their authority. As I say usually about these federal agencies, and listen, I have Indian friends and they can't stand the Bureau of Indian Affairs. And the Bureau, we know the Department of Interior and its track record, and the USDA and the Forest Service. These guys in the last 30 years in particular have almost become lawless. I have depositions to prove this, so I'm going to say it. They have become lawless. And so when you read their stuff, it is so important to understand the underlying law and read it in that context and understand what they've done. And by the way, listen, I believe whoever's got property rights out there, and I don't care whether it's tribal rights or otherwise, we need to defend those property rights or they're play fair. Let's put it that way. But when the Bureau of Indian Affairs is playing games, we also need to call it like we see it. I didn't see anybody getting water rights out of that deal. So let's read water rights federally recognized for Indian tribes. Again, which I defend. The Indian tribe may have a federal reserve water right claim in Oregon. So that was the position of the legislature in 1987. And then it goes on to say that they can impact water rights, but only water rights that came under the statutory water law scheme. So water rights that were certificated or permitted. So any water rights that go back behind 1908, theoretically, now I'm saying theoretically because it has to be fought out and defended, but theoretically cannot be impacted by this Federal Reserve recognized Indian tribes claims under a Federal Reserve water right. I'm going to say something. The Forest Service filed a bunch of Federal Reserve water rights up here, and so did the BLM. And I'm just going to tell you, in our case, we successfully beat those. So, again, the purpose of an adjudication is just to determine who has what rights and so forth, and not to disprove that somebody had An adjudication does not, if you have vested rights and you have evidence of it, the adjudication should recognize those. That's, I guess, what I want to say. Moving along. A lot of people, as I said, don't know what savings clause language looks like in a statute. So let's read one of the best laws. And remember, the Federal Land Policy and Management Act encompasses all federally managed lands, I believe. I shouldn't say not tribal lands, but I think in almost everything else comes under the Federal Policy and Management Act, 1976. Nothing in this act or in any amendment made by this act shall be construed as terminating any valid lease, permit, patent, right-of-way, or other use right or authorization existing on the date of the approval of this act. Oh, and there they go again. All actions by the Secretary concerned under this act shall be subject to valid existing rights. Okay? Now this is one of my favorite ones. How many of you guys, and Danny's going to get into this a little bit, has anybody had one of these agencies show up with one of their rent-a-cops packing guns? You know what I'm talking about? Forest Service BLM, they come with lights on their cars and badges and guns. Well, let's read what it has to say about that. Federal Land Policy and Management Act, 1976. And by the way, this is consistent through all of the federal land acts, by the way. Nothing in this act is expanding or diminishing federal or state jurisdiction. Remember, state and federal jurisdiction come under the Constitution. The federal jurisdiction comes under the enumerated powers outlined in the Constitution, and everything else was reserved to the states. It's still that way. You guys, the Constitution still exists. Oaths of office for county and state officials are still in place, where they swear to uphold the laws of the Constitution of the United States. I have one. The laws of the Constitution of the state and the laws of the state. Your state officials do not swear to uphold the Endangered Species Act. They only swear to uphold state law. So let's go back to this. As expanding or diminishing federal or state jurisdiction, responsibility, interests, or rights, or water resources development or control. And under number 6, as a limitation upon any state criminal statute. Police power is a function of the state. Or upon the police power of the respective states. Or as derogating the authority of a local police officer in the performance of his duties, or as depriving any state or political subdivision thereof of any right it might have to exercise civil and criminal jurisdiction. That is a function of the states, and we often forget it. We need to push back on this one because these guys are running around in cop cars, basically impersonating law enforcement officers, issuing citations that send you to federal district court and not to the local state court. So that's an area, I won't get into it, but that's an area you need to pay attention to. I'm going to cruise through some of this very quickly because I have given you a handout. What's my time left, by the way?
Got about another 8 minutes.
Oh, lucky for you. I'll cruise. And I want to just give you an overview very quickly of what a chain of title looks like. A chain of title, first of all, is a list of predecessors going back to the very first appropriation of the land and water. And you usually document that chain of title initially through a list of deeds or conveyances back to the original settler. Once you acquire the list of predecessors and then the list of deeds, or you copy the list of deeds, I should say, out of the recorder's office, and the patents and the homestead entries and the surveys, then you can fill in the blanks a little bit with some of the appurtenances. In the ranching industry, you need to document your use of stock water. So it's good to get assessment rolls, for instance, because it usually documents how many cattle an operation had. In Nevada, we have many old homesteads, are about 160 acres, and voila, they have 1,000 cows. Now, I don't know what your pasture is up here, but there's no land in Nevada that I know will carry 1,000 cows for a year. So it indicates that cows were out on the range. You can include tax records, you can include bills of sale for range and water, you can include old surveys, USGS surveys showing irrigated acreage, or any other evidence of irrigated acreage. your irrigated acreage often turned up in the assessment rolls as well. You can include, you would also, if you have a grazing allotment, you'd want to get all of the Forest Service to be able to have records from you and historically on that range allotment. Other records you could use are tax, mortgage records, and so forth. I think I will leave it there because I've given you a pretty detailed outline on some of this. Let me just thumb through this very quickly. I've given you tips and tricks, where to look. This is a proof of a vested water right. One of the things that we had to do is go back and document our water rights, because a lot of our water right filings were filed after the statutory water law, yet we knew that our predecessors in interest were using that water, springs and so forth, well before, clear back into the 1860s. So we went and refiled a proof of the vested water right, and you may need to do the same thing. This is a certificate of appropriation, probably very similar. A map of the ranch, a title plat map, which shows where the patented property is. This you can get off the General Land Office website now to the county recorders and assessors offices. A legal description of the ranch, I'm just going to blow through it. History. Okay, I'm going to make one comment on this and then just wrap up. This is what I call an abstract of title. And when I was in court, I would testify for 2.5 days over 500 title documents that were exhibits. I had to get into evidence under my testimony, and basically the whole case hinged on that evidence. If you don't have evidence in court, if you don't have evidence of the law, to the judge it doesn't exist, whether he might know about it or not. So you have to get your evidence and your law before the judge, or really it just doesn't exist to him. But here I am on the stand with 500 documents, and none of us wants to read those documents one by one, especially the judge. And so I had this abstract put together, and in the far right-hand corner was a remarks column which had all of the legal description and all other relevant information, such as a conveyance of range or a conveyance of a brand or numbers of livestock or whatever. And, okay, I'll tell you a bedtime story. I had a DOJ attorney who was going to be doing my examination, and he was a real nitpicky bean counter, and I knew he was just going to try to pick me to death. And so I had given them all this information a year and a half before in my deposition, and it became pretty apparent as the trial came close that he had really not studied these records. And when you read a chain of title or doing title work, especially with a lot of documents, it's a little bit like reading spaghetti. And so I had an abstract, a list of documents for 7 ranches, basically, that all became part of Pine Creek Ranch, and I had them individually identified. And I thought, do I give the government attorney those separate 7 abstracts, or do I put it all together chronologically? And so I decided to shuffle the deck. And so I put them all together, they're all chronological. I knew the record, and then I made myself a little cheat sheet in that one column identifying which ranch that property was related to. And when I was testifying, it looked like I was really brilliant. I really wasn't, but it went very well with the judge, and he actually ended up being, I think, somewhat impressed with it. So if you think you're headed to court or to a hearing having to do with anything with title, if you do something like this and put the pertinent information in that remarks column, you don't have to, as you're on the witness stand, testify about you don't have to read off of original documents. You can use your cheat sheet. That's a survey. That's about it. Oh, one other thing, if you're in your title documents in the recorder's office, look for old decrees. Many times these waters were adjudicated historically in a dispute between neighbors, and we don't know that. And those decrees are actually binding on subsequent court cases. So you do want to look for court cases. All right, I think with that, I'm going to wrap up and bring Danny up, or Debbie. And I want to thank all of you, and I hope that this can help you.
Can you tell that Ramona's spent some time in her private property rights and in a court? How many people are learning something that you didn't know prior to coming here. Oh, that's great. Good job, everyone. A couple things. We will have a donation bucket. Diane's got the donation bucket, and again, is it going around now? Okay, great. Oh, yeah, Gus has the donation buckets. And again, this is not only to help pay for our wonderful speakers today. I give them a round of applause. But also to help pay for this venue, and your community wants to have more educational events like this. So they're hoping that, that the donations can help go towards future events for Klamath Falls. So on your seat is a index card. Danny's going to talk for about 20 minutes, and he's going to have lots of fun. And then we're going to open it up to Q&A. Yeah. He thinks he can get it done in 20 minutes.
I've been in this battle for my rights probably since about 2004. I got introduced to some of these property rights through the Hage family. I took all their cases and I reviewed them, and I expanded upon that. I've been in federal court numerous times without an attorney. I never found an attorney that that knew these issues. So I had to do a quick learn on law and procedure. Throughout the process, I've learned a lot, and I'm here to share this stuff with you. We decided collectively through decisions that involved the Hages and myself and David Spady. He's the gentleman with the wolf situation. He's a board member. There's another person that's involved. It's Kathy McDonald's. She's out of Vancouver, Washington. And so what we decided to do was create a foundation so that we could catalog and to research the laws and provide a service in that area, which we felt was a little bit on the weak side as far as the attorneys go. So the purpose and scope of this foundation really is a research foundation to do a study of the laws, see how they're written. I've done a lot of work in that area. I've become very versed in water law. I've studied a tremendous amount of procedural law, because in our system of law we've got substantive law, and then we've got equitable law, and our system of the courts right now are a blend of both law and equity, and Michael talked about this equitable sustainability, or whatever they're talking about in Agenda 21. But there's a set of rules. These are laws that have been enacted, but they're called rules of the court. Now, the rules of equity were developed back in England. They were the old chancery courts. Now in England they had courts of law, and they had chancery courts were the equitable courts. Sometimes law was a little bit harsh in its remedy, so then they created the equitable courts, which gave equitable relief to either one of the parties. It could be the plaintiff or the defendant. It gave the judge a certain amount of discretion to either rule that way. Well, in the United States, there's law and equity, and they're blended into one. The rules of the court. That's one reason I'm very familiar with those. But the rules is that equity always follows the law. So when I learned all this, I realized that it was law and procedure that we had to plead when we went into court, and I sort of fine-tuned this a little bit in my cases, and also, when I participate, I didn't really participate in the Hage case, I was primarily there as a backup, so in case something came up, that I was there to tell them what the law said. Because I've read Flipman, I've read Taylor Grazing, the Unlawful Enclosures Act, I've read them all, and that's what gives me, I guess, my approach to this solution when you do go into court. Ramona talked about some of the things we did. We were Ramona was in the trial, and Wayne was defending himself, and we had the Hages had hired Mark Pollock, which is an extremely competent constitutional attorney that was representing the estate. But Ramona had she was a non-party to the case, even though she was one of the heirs. But she'd gotten this subpoena from the federal government, from the Department of Justice, and she called me up, and we were just talking about it, and I asked her, I said, if she wanted to have a little fun with this subpoena. and I know she thought I was nuts. But we had a situation here where they had all of these decisions out of the Federal Court of Claims, and yet we couldn't get them procedurally into this case, because this was really the remedy. So when and I'm just talking about the procedure of what we used. So when the DOJ subpoenaed Ramona to come in with all the records, see, we decided to have a little fun with this thing. So I told Ramona I'd help her with the paperwork, and so we did have some fun with this thing. We actually did a motion to quash the subpoena, and so that means that we're asking the court to take this thing and squash it. That's the term used for this thing. And but what it did was it gave us an opportunity to bring up all of these issues that transpired in this other court. And see, I did the paperwork, so it's easy to take yourself as a victim if you're not the victim, because sometimes you're a victim and you've got a lot of anger and a lot of anguish in your heart. It's hard. So I did the paper for Ramona and painted her as a real victim, and the Hage family is a victim of abuse from an oppressive government. That's really what it was. And so we had to have a hearing on that, because I had done a motion to intervene. Now that's like going to the dentist and asking for a root canal when you just need your teeth cleaned, But I wanted to intervene in the case. It's part of procedure. It's Rule 24. And I said, look, I have an interest in the outcome of this case, because we had taken a couple of cows. Mr. Alt here, sitting in the front row, and branded a couple of his cows, and we put them on the Hage Ranch so that I'd have them standing to be before this court. So I did a motion to intervene, and then when I started asking the government questions, there was a tremendous opposition to my intervention from the Department of Justice. So I called Ramona and said, you know what, they're not going to let me intervene, Ramona. I'm telling you, this response from them is too great. So I said, why don't you intervene, and I'll do the motion and everything for you. So Ramona did a motion to intervene as well, and then we had a hearing on our motions. The judge denied our motions, and it was rightfully so. He didn't want to muddle up the case. But in the hearing, he wanted every court case that involved the Hages, from the water adjudication to the criminal charges against Mr. Hage to all of the records and decisions that came out of the Federal Court of Claims. Now we had the whole record before this court. So now procedurally, you cannot be in trespass when you're there of right. And secondly, that we did was, and is extremely important, because we think that federal law supersedes state law. But that's not the way this country was formed. The only time that federal law supersedes state law, that's one of those 8 enumerated powers that are in the Constitution. Everything else is state law. State law governs. It was in the first Judiciary Act. It was passed in 1789. It was in Section 34. It was reconfirmed by that Erie Railroad Doctrine. It's an Erie Doctrine. You've got to follow state law. And then, in 1948, Congress passed another law. It's called the Rule of Decision Act. And it specifically states there that in civil cases, in federal court, you have to use state law as a rule of decision. So when the Hages and the attorney picked up on all that, we used the elements of trespass under state law. Well, we couldn't be in trespass. Couldn't. So I have a case right now before the Federal Court of Claims. It was a situation where there was a dispute over property with one of the federal agencies. My ranch happens to fall right within this wolf designated area. They wanted my families out of there so they wouldn't have to deal with them. And they wouldn't, they just took their property. So I did something there that, or they came at me under the Endangered Species Act. I'm just sharing a lot of this with you. So I'll share with you what I've learned and how I defended myself procedurally. I got a 60-day letter of intent to sue under the Endangered Species Act. Some of the proposed plaintiffs were the Defenders of Wildlife, Forest Guardians at the time, Center for Biodiversity, federal employees for whatever it is, And so when I got this 60-day letter, I decided I would respond administratively. At that time, rather than allow them to come forward and sue me, I took the offensive. And I used the Administrative Act as my defense. And I immediately started asking them questions. First of all, I wanted to know who the damaged party was, because under the Constitution that's standing. I asked them how the Endangered Species Act applied to me. I wanted to know how the Endangered Species Act applied to me within the boundaries of the state of Arizona. But before I could ask all of these questions, I had to have read all the laws, the Supreme Court cases involving the Endangered Species Act. I read the Endangered Species Act to see what it said. And the Endangered Species Act is treaty law. It only applies within the federal system. And so when I read that, and it said specifically in the Act that the Act was pursuant to 7 treaties. It's treaty law. And that they needed to get cooperation from the state. And then it goes into great detail of their authority to make rules and regulations. Doesn't say anything about making rules and regulations about the introduction of wolves, but into the disbursement of these funds to the state. So when I read all of that, I realized that just like Michael was talking about this one world government, the federal government is bribing our states and our state officials to do their bidding and to enforce federal law. There's no provisions under the Constitution for that. There's no provisions under state law to do that. In fact, the social compact between the state public officials and the people is that they uphold the Constitution of the United States, the Constitution of the state of Oregon, and the laws of Oregon. It says nothing about federal law. So in that case, we've got major problems because they are imposing a fraud upon us. Well, in my case, they decided they didn't want to bring this case to trial because these issues were going to come out. Now, what has happened, and I'm just explaining what procedurally, how they go about doing all of this stuff. See, first of all, they need to have the states sign on to it. And then they go through this elaborate procedure of making rules. You know, Debbie talked about that. You know, down in Washington, they're going to have a hearing. This has to do with the rulemaking authority. See, so they can make all the rules they want. But to me, as one of the sovereign people, see, I know who I am. I'm not a subject of government. I'm a subject of my Creator. You know, these unalienable rights I will not waive to anybody. Anytime that my rights are going to be infringed upon, I'm going to fight back. You know, our government, the way it was formed as a republic, our government can only legislate for three things: health, welfare, and safety. That's the function of government, to protect our property. There's all of these rules, there's all of these laws, and I always ask myself, are they applicable to me? Because I know who I am. And I always ask that question. How are they applicable to me? Now, we talked about Holly talked about the executive order. Doesn't apply to me. I'm not a federal employee, and I'm not an employee of the executive branch. Doesn't apply to me, so why am I going to get upset about that? You know, so I'm a consultant for a county in Otero, New Mexico. I consult with them. I was asked to do this only because I got to know a couple of the people there. When I sat on Paragon's board down there, I made a mistake of opening my mouth, and they asked me to consult with them in regards to all of this legal stuff that has to do with the county interfacing with the federal government. See, and I always know all this because I had to read all that stuff. See, and I remembered all of it. We got a situation there where the county had declared that the forest had excessive fuel load, and it posed a potential hazard to the communities when there. If they figured if the fire started and it started in a certain canyon with the winds hitting, that the town wouldn't be there. I mean, it would lower the whole town. So what we did was the county, on their advice, I advised them to pass an ordinance, declare an emergency, pass an ordinance, and invoke the police powers of the states under the 10th Amendment. And we just happened to have another case in the New Mexico statute that said that basically the same thing. Well, these bureaucrats don't like their little turf and their authority challenged. So they didn't like that. What they did was they did not stop the negotiations and the working together as far as cleaning up the forest, but they initiated a lawsuit against the county and the state, claiming that the ordinance and the state law violated federal law. But it doesn't, see, and they're claiming preemption, they're claiming the supremacy clause and all of that, and that's not applicable. You know, and I'm involved in that case, involved in the case as far as RS 2477 there, on the right of ways on that. It has to do with a mining thing. There was 3 ranchers that had gotten a criminal citation. They claimed that they were interfering with the duties of a police officer or a law enforcement officer or a federal employee. So the sheriff there wanted to bring this to court. And so we decided, we had a conference call, we decided we'd use these three criminal citations to challenge the federal government's criminal jurisdiction within the county, see. So we decided that we do a writ of habeas corpus under state law. So that's a writ of habeas corpus is one of the ancient writs designed to challenge our restraint of our liberties. Now, even though he wasn't in jail, the citations were a restraint on his liberties. So we went into the. I was working with the county attorney. I did all the paperwork for him as a paralegal. We submitted into state court for the writ of habeas corpus. The state court got spooked by it, didn't want to issue it, told us we had to go to federal court. Then I had to read all the rules. So you got to read the law and the rules in order to play the game within their system. And in the federal system, you basically have to be incarcerated. So that didn't work. So then the next thing we decided to do was, well, let's just challenge the court's jurisdiction. Now, attorneys can't do that because they're an officer of the court. So we went through the paperwork there procedurally. There's three of them. One of them didn't want to mess with it. He just pled guilty. He paid $150 fine. And the second guy was acquitted. The third guy, they figured he was the most vocal of all when he told the Forest Service to get the hell out of there. I guess that's interfering with their duties. So we decided we'd challenge it. So we challenged, immediately came out with a motion to dismiss for lack of territorial jurisdiction under the criminal system, see? And all this stuff I pulled out of the U.S. Attorney's Manual. So the court ignored that. The guy went in for a hearing. The judge entered, it was a magistrate judge. The judge issued said, well, since you won't plead, I'll plead for you and not guilty. And then he calls me after the hearing. He said, well, the judge pled not guilty for me. And he said, he doesn't have any authority to do that. So I said, well, the Magistrate Act doesn't authorize him to do that. So we did a motion to strike the judge's plea. See, if we are sovereigns truly, not if we are subjects of our Creator, we can do a lot. But if we're subjects of government, we can't do anything. So we challenged that. Told the judge he had to strike that. And so then they called him up and said he had to have another hearing. I said, okay, make sure you go to the hearing. Don't be disrespectful to the court. I'm coaching him on procedure. He gets there, and the judge, they're masters at this. They teach him how to screw with you. So he goes in there, and the judge says, you don't know what you're doing. You need an attorney. He says, I'm gonna get you a court-appointed attorney. And the guy said, okay, well, he was feeling a little intimidated by this whole thing, so he agreed to it. And then, of course, he gets out of there, and I said, how did it go? And he said, well, they're going to appoint me a court attorney. He said, that's a good thing, isn't it? And I said, heck no, because an attorney is an officer of the court. He can't challenge the court's jurisdiction. He's an officer. He's going to plead not guilty for you. So he said, oh, God, I screwed up. I said, no. Procedurally, you never screw up. You correct everything. So we did a motion to strike his application for a court-appointed attorney. He said, I don't need an attorney, but as soon as you file a proper complaint, according to the criminal rules of procedure, Rule 3 is real specific. It says there has to be a complaint made before a magistrate or some sort of public judicial officer. At the minimum, a notary public. Well, it's not there. See, because there's no law that you're violating. They just suck you in to waive your rights. See? And so we said, I'll gladly appear when there's a proper complaint made by somebody that has firsthand knowledge of the facts, and until then, I will await a proper summons under Rule 4. Now, summons can only issue upon a complaint. So that's been about 3 weeks. We haven't heard anything, and I don't think it's going to go anywhere. And that situation will probably die a slow death. So I'm trying to think some of the other things that I've done. Last Tuesday, there are things happening other than here. Arizona's upset about the wolves. They want to do something about it. I know a lot of legislators there, senators. I've been invited to go down there and speak before the Natural Resource Committee numerous times. I go down there at least once a month. Tuesday I met with the President of the Senate. He wanted to do something. I kind of went over some things. I'm not an attorney, so he was an attorney himself. He wasn't sure of my qualifications. So then he got back to us the following day on Wednesday saying he wanted a lot more information. They're really concerned of what I want to do. The Attorney General of the state is a constitutionalist, a very fine man named Tom Horn. He is very interested in taking on this battle. And so probably in Arizona will probably take on the introduction of that wolf or the rulemaking authority in Arizona on probably procedurally numerous procedures. One of them, we're going to attack the EIS, which is the Environmental Impact Statement that the environmentalists whipped together in 1996. It's flawed. I've had a couple of scientists take a look at it. They used junk science. They did follow proper scientific methodology in it. Part of NEPA requires them to do an economic impact study on that. And also the rules in NEPA, and I've read all of them, is that they have to use the best science available. And they didn't do that. And one thing is, like the introduction of a wolf, and also if there's any federal money on the proposed destruction of these dams, here they've got to do a NEPA study on to find out what the economic the environmental impact is going to be. But part of that is an economic impact. Now, any impact that's over $100 million has got to be approved by the Office of Monetary and Budget. And that EIS that they did for the introduction of the wolf in 1996, it came in at $80 million. They just pencil whipped. They underestimated the economic impact. It failed to consider the psychological impact that we've got to communities and people. That the children, and like testimony here on the film. So these are some of the things we're doing. Hopefully, as we get this thing going, Ramona's working on the website. Once we do that, we feel that as a foundation, as an organization, we can raise funds to do the study and to look at every law possible. I've studied statutory construction and interpretation. There's canons of construction of the laws, and part of my self-education process. It's helped me when I look at a law. I know what I'm looking for. It's just like in your Oregon Water Code. It talks about these subject to valid existing rights. Subject to means that the law is subordinate to the rights. And a lot of times we don't know this. When we go into court, we hire an attorney. He doesn't know. We assume that they taught him that in law school, and so we're not arguing the right things when we go into court. And hopefully, if we establish the law of the case, whatever it is, that we can help people defend themselves. also procedurally. I think that if we can teach people how to defend themselves procedurally in court and not waive any of their procedural due process rights, I think that we can push back, because every one of us will be a wrench in that well-oiled machine that they've got. Oh, a criminal citation?
When you get a notice in the mail and pay $30,000 for some salmon.
Oh,
Doesn't it sound-
okay. Are the generous here?
No.
Okay, they received a letter basically stating that they had violated the Endangered Species Act, that they had by diverting a stream that they had taken I think 15 salmon of it. Of course, when I looked at it, the agency that sent them the thing had to do, it was NOAA, National Oceanic Administration or something. What's that got? This is in inland. We're not out there in the sea. And if you look at the Endangered Species Act, it's subject to these treaties. Okay, but we're not out in the sea. Secondly, he may or may not have known that there was salmon in that creek if he did. And if it was, it could have been planted. We don't know. So basically, my approach would be to engage him in an administrative process, make an administrative record, so that now, if you have to go to court, you've already got a record. In my case, the U.S., before they came and stole the cattle, they couldn't get a court order or warrant. The court wouldn't give them one. Because when they sent me that initial letter of trespass, I responded to them by sending them my chain of title, and I said, I'm sorry, I thought it was on my property. And I said, but we can settle this thing amicably. We don't need to go to court. I said, I'll tell you what, I'm going to bring my title, and I want you to bring your title, and whoever's got the higher title, hey, listen, you got a title of that land? Hey, I'll make myself subject to you, but until that happens, I'm assuming that I bought property. Well, you know what? I asked them about 80 questions, and every one of them I knew the answers. You never ask a question unless you know the answer. They wouldn't respond. I even offered to meet with them, whatever. They would not respond. And I just didn't send it to the U.S. Attorney of Arizona. I sent it to the Regional Forester. I sent it to all the way up to Washington, D.C., the Attorney General. I was not timid about this. I sent it all the way up to the Secretary of Agriculture. I sent it all the way up to the Secretary of Interior. I sent it to all of them. Nobody would answer or respond to those questions. That was the administrative record I was creating. And under contract law, they failed to respond. And that means they gave consent. So the key is anytime they send you a letter and engage you, they're making you an offer to enter into some kind of negotiation. Don't ever ignore those. You've got to respond to them. Because that's your opportunity to start setting the administrative record. It's procedural. It's procedural. Because there's an act of Congress called the Administrative Procedures Act. It's a very powerful act. Every state has got one. It's called the Uniform Administrative Procedures Act. California's got it, Nevada's got it, Arizona's got it. Everyone that has adopted that. It's a procedural due process protection against administrative agencies. Thank you.
Thank you.